Hello everyone. This right here is the third case I'm facing. It's based upon the video that I already posted of my interaction with the court officers as a result of not wearing a mask. And so yes, this is about not wearing a mask in the courthouse. This is what they charged me with, and this is the motion to dismiss. Also, I'd like to make it aware that the ADA, Assistant District Attorney in the case, handling the case, nor the courts have provided me with audio or video recording of that day in question where they actually physically assaulted me for not wearing a mask. As soon as I stopped filming is when they actually assaulted me. And as soon as I do get that video or those videos, I will be posting those up for you guys to see. Okay, so motion to dismiss. Defendant Mr. Jeffrey P. Donnelly respectfully moves this honorable court pursuant to Massachusetts Rules of Criminal Procedure, Rule 13, to dismiss plaintiff's complaint. Charges of Massachusetts General Law, Chapter 272, Section 53F, disorderly conduct, Chapter 268, Section 32B, resisting arrest, and Chapter 268, Section 13C, court proceedings disruption. In support of this defendant's motion, the defendant further incorporates the reasons and precedents contained in the defendant's memorandum of law in support of defendant's motion to dismiss that is incorporated by reference herein. Wherefore, Mr. Jeffrey P. Donnelly respectfully requests that this motion be allowed. Motion to dismiss. All right. So now we're getting to the defendant's memorandum of law in support of defendant's motion to dismiss. This right here is where the meat and potatoes are. The defendant, Mr. Jeffrey P. Donnelly, submits this memorandum in support of its motion to dismiss. Facts. Mr. Donnelly is being falsely charged in this case with 3 separate counts brought by the Palmer District Court trial court officers. This case was brought forth on the same day that Mr. Donnelly was supposed to have his motion to dismiss heard, concerning an alleged incident alleged to have occurred over 5 years prior, an incident that the Munson Police Department not only discarded evidence in, the alleged victim refused to turn over evidence in, but in which the police did not believe that Mr. Donnelly had committed any wrongdoing in over 5 years' time, and it was only filed when the Assistant District Attorney Parsons compelled them to. Mr. Donnelly had alleged in his motion to dismiss bad actions by not only the Hamden County Assistant District Attorney Parsons, but also the Palmer District Court Clerk, Magistrate. The new charges that have been brought forth against Mr. Donnelly by the trial court officers, Palmer District Court, and alleged to have occurred on June 9th, 2021, are as follows: disorderly conduct, resisting arrest, and disrupting a court proceeding. Mr. Donnelly had been the victim of ongoing documented state corruption since 2009, when he had taken out papers to run for the United States Congress. Stated documentation from the early years, starting in 2009, is documented in the state-censored book that Mr. Donnelly authored, being Raw Emotion and Political Repression, published in 2012. Prior to Mr. Donnelly taking out papers to run for the United States Congress as a 25-year-old common-sense Republican, Mr. Donnelly had accomplished many things in life, including earning college university degrees in criminal justice and psychology, having had gainfully employment within the system, including supervisory positions in the private personal security sector, including it being a recruit Springfield Park Ranger, a rover officer for one of the largest private security firms in the world, and being a youth direct care worker on a Massachusetts Department of Youth Services detention unit, Westfield. While at the same time, Mr. Donnelly was working on a second bachelor's degree in art education with teaching credentials in K-8 and 5-12. Prior to becoming the victim of governmental corruption, Mr. Donnelly is also a first-generation college graduate who overcame a learning disability in the process. On March 25, 2021, in the middle of a global pandemic, Hamden County Assistant District Attorney Dana Parsons contacted Lieutenant Nicholas Gasparini and advised him to file charges against Mr. Donnelly. Being 5 years after Lieutenant Gasparini had sent the complaint to the District Attorney's Office for a standard review, not listed as urgent or reply, and in fact, Gasparani had told Mr. Donnelly in 2016 that he didn't think anything would come of Miss Blank's complaint, as her story had changed many times and appeared unlikely. It is stated in Lieutenant Gasparani's report that Assistant District Attorney Donna Parsons had contacted Miss Blank to see if she wished to proceed with charges after 5 years had gone by, and out of the blue it is not mentioned if ADA Parsons had promised Miss Blank any money or other compensation, as the Hampden County District Attorney's Office, Massachusetts Attorney General's Office, had done in the past in order to get a witness, alleged victim, in a prior case against Mr. Donnelly. A case that Mr. Donnelly had won. The alleged victim in that case had admitted to being paid by the District Attorney's Office, Massachusetts Attorney General's Office, several months later in a recorded hearing, in which the presiding judge was very surprised to hear, as he had just been the same justice who had presided during the jury trial, that Mr. Donnelly had won. Yeah, see, that's something major, because in this case right here, well, in the other case, in the victim impact statement, which they gave me without finding it guilty, which makes no sense at all, but with that case right there, the alleged victim's claiming that they're not giving her any money, but then she's trying to go after me but then again, she wants restitution for massages for $1,280, when the person who she said did the massages never did any massages on her, and it makes no sense at all. But yeah, the person's trying to get money, backdooring it that way, and there's really, who knows if they're actually paying the person to be a victim too, which is very likely. Alright, so let's get back to this. On March 31st, 2021, Lieutenant Gasparani called Mr. Donnelly on the phone and told Mr. Donnelly that the District Attorney's Office was pushing him to file charges against Mr. Donnelly on a 5-year-old incident, and that Lieutenant Gasparani didn't understand why, but that he didn't want Mr. Donnelly to be blindsided and end up being arrested for a warrant. Mr. Donnelly thought this was a joke, so he went down to the Palmer District Courthouse in order to see if it was legitimate. The court officer, Hart, provided Mr. Donnelly the phone number to the clerk magistrate's office and to the Palmer Assistant District Attorney's office, and no one had any information. All they said that Mr. Donnelly was not facing any complaints. This was a lie, as the complaint had been filed on March 30th and somehow by some unknown individual had been approved on March 31st, the day that Mr. Donnelly had come to the court. Mr. Donnelly then went to the Munson Police Department. Lieutenant Gasparani refused to speak in person to Mr. Donnelly, but an officer told Mr. Donnelly to keep in contact because the charges had been filed at the insistence of the District Attorney's Office. On Friday, April 2nd, Mr. Donnelly was contacted on the phone at around 10 a.m. by a Munson police officer who asked Mr. Donnelly if he knew that he had an arraignment scheduled for 9:30 a.m. that day. Mr. Donnelly stated that he had not been aware. The officer asked if he was able to make it before noon, and Mr. Donnelly said that he could, and the officer told Mr. Donnelly that he would notify the court so that warrant wouldn't be issued. Mr. Donnelly is aware of how the court is supposed to operate, as he has faced a number of false charges brought by the Hampden County District Attorney's Office in the past. And Mr. Donnelly is aware that it is the courthouse's responsibility to contact the defendant and inform them of when an arraignment are scheduled for. It is also not normal for a court to schedule an arraignment 2 days after the court allows a complaint to issue, as the Palmer District Court did in this case. If the Munson Police Department officer had not contacted Mr. Donnelly would have had a straight warrant issued for his arrest for not showing up. And due to the Easter holiday, Mr. Donnelly would have spent Easter in the Ludlow House of Corrections as a result of the actions of the Palmer District Court's failure to provide proper notice. Besides not sending proper notification to Mr. Donnelly about the arraignment, when Mr. Donnelly arrived, Court Officer Hart told Mr. Donnelly that the court wasn't doing in-person arraignments and tried to send Mr. Donnelly away. Mr. Donnelly insisted, and the court officer made a couple of calls, was surprised when he found out that Mr. Donnelly had one scheduled. The case that Assistant District Attorney Parsons made the Munson Police Department file is actually unethical, if not illegal, and should not have even existed in the system, because the criminal complaint is not signed by the complainant, nor is a name filled in for one. Also to note, the complaint was not sworn to before a clerk magistrate, assistant clerk, as no clerk magistrate signed off allowing this charge to be filed. Major issues with the application for criminal complaint in the Munson complaint also shows the criminal complaint to be unethical, unlawful, such as no boxes being checked off requesting a hearing. Neither of the I request a hearing without notice or with notice to the accused are checked off, as is required. Arrest status of the accused is checked as has not been arrested, yet the bottom of the page, where it says court use only, lacks any dates or clerk judge's signatures or initials, such as where the clerk judge would state when the notice was sent out to inform the defendant of when a clerk's hearing was to be held or an arraignment. Also, the box where finding a probable cause for a complaint would be marked along with how defendants would be notified of their arraignment, be it a warrant, a summons, or an arraignment. Date was not filed out. During the Munson case's arraignment hearing, Mr. Donnelly had requested his right to a speedy trial by a judge, and instead of being provided a trial date, he was provided with a pretrial date of June 9th, 2021, a date on which Mr. Donnelly ended up being abused and arrested while he was peacefully waiting for his motion to dismiss to be heard, and had the Palmer District Court refused to hear his motion to dismiss that had been scheduled to be heard on that said date. Even though Mr. Donnelly had been in the courthouse, they unlawfully refused to call his case Munson PD had filed. The justice who presided over Mr. Donnelly's arraignment in the Palmer District Court allowed Mr. Donnelly's request for a speedy trial and set the nearest date in opposition to what the ADA was requesting. Mr. Donnelly's only terms of pretrial release were that he have no contact with the alleged victim, Miss Blank, and that he commit no new crimes. Mr. Donnelly had no issue with these conditions, as he had no wish to contact Miss Blank, as he had no contact with her in over 5 years. Nor did Mr. Donnelly intend to commit any criminal activity, as no criminal activity had actually been claimed against me in well over 6 years, 7 years or more. And when it was all false stuff. And it was, before then even. Hamden County Assistant District Attorney Donna Parsons has a documented history of being found guilty of ethics violations in the past. In the past, she has used her position as an Assistant District Attorney, an official office space in the city of Pittsfield, Massachusetts courthouse, in order to campaign for a Democrat political candidate for political office, in direct violation of Massachusetts general laws. Assistant District Attorney Donna Parsons also led a white male Democrat who not only assaulted an Indian/person of color candidate for the United States Senate, but whom also chipped 2 of the candidate's teeth and busted his lip off with only probation and a fine. This candidate has run for office in Massachusetts as a Republican. You see that? Massachusetts is a one-party state. When you're in a one-party state, whether left or right, and you're a member of an opposition party, you deal with a lot of corruption because, well, especially in Massachusetts, which is blue as blue can be. Mr. Donnelly has attempted to run for office in the past as a common sense Republican, causing this case, Munson case, to appear politically motivated. This case, Munson case, appears to have been filed with the appearance of interfering with Mr. Donnelly's renewal of his firearm license, and with any future political campaign that Mr. Donnelly attempts to partake in, as Assistant District Attorney Parson had compelled the Munson police to file a charge of indecent assault and battery on a person over 14 against Mr. Donnelly without any evidence or proof after 5 years after the complaint had been made, when in fact the Munson Police Department had already deleted all the video and audio statements that they had because they didn't believe that a crime had been committed. Okay, like it says over 14. The woman was like in her mid-30s who's making this complaint, all right? So just remember, person's mid-30s, like 40 years old right now, like over 40. So over 14, like over 14. Over 30, over 35, yeah. So it says nothing to do with the children or anything like that, just remember that. Mr. Donnelly campaigned 2 years ago for mayor of Springfield, where every debate Mr. Donnelly was pushing the issue of local corruption by informing the people that the city of Springfield's police department finds him suitable to have a firearm license, but not a hawker and peddler's permit to sell the book that he wrote that exposes corruption. Raw Emotion and Political Repression is the title of the book. Assistant District Attorney Parsons compelled the Munson Police Department to file these charges in the middle of a signature gathering time period for candidates to make it on the ballot for local elections. And an allegation of this magnitude, even if false, would have dire consequences for a candidate running for an at-large seat on the Springfield City Council, as Mr. Donnelly was doing. An Assistant District Attorney Parsons' office is located in Springfield, Massachusetts, the very same city where Mr. Donnelly has attempted to gain a political office in. On April 22, 2021, Mr. Donnelly went to the Palmer District Court in person and served the District Attorney's office, Palmer office, in hand with his motion to dismiss Munson case, as well as filed a copy of his motion with the clerk's office. Mr. Donnelly's motion to dismiss clearly exposes and details corruption within the Palmer District Court. On April 23, 2021, the day before Mr. Donnelly's Massachusetts Class A license to carry was to expire, Mr. Donnelly sent in his renewal application. Within his renewal, Mr. Donnelly disclosed the Munson case, even willing to provide them with a copy of his motion to dismiss and all other paperwork. Mr. Donnelly also informed the Springfield Police Department that if his license was not renewed, that he was going to be removing his property, firearms, from the Commonwealth of Massachusetts and into a state where he was still lawfully allowed to own firearms in, being that of Vermont, which is about an hour or less from Springfield. On April 24, 2021, being both Mr. Donnelly's birthday and the last day that Mr. Donnelly had a valid Massachusetts Class A firearm license to carry, Mr. Donnelly removed his private property, being firearms, from the Commonwealth of Massachusetts and into the state of Vermont, just in case the city of Springfield attempted to interfere with his ability to lawfully own firearms in the Commonwealth of Massachusetts, such as attempting to confiscate his lawfully owned property. Mr. Donnelly is not just a firearm owner, but also a firearm collector, with most of his firearms being of vintage or antique in style, ranging from the 1870s to the mid-1900s. Mr. Donnelly was first granted a Massachusetts Class A license to carry firearm license on September 17, 2009, from the city of Springfield, Massachusetts, and has since renewed it at the proper intervals. For over the past decade, Mr. Donnelly has willfully complied with every legal request made by the Springfield Police Department in regards to his firearm license, even when the Springfield Police Department had been proven to be in the wrong. In the past, the Springfield Police Department had unlawfully revoked Mr. Donnelly's Class A LTC. In this case, Mr. Donnelly immediately abided by the deputy chief's order and then filed an appeal with the courts. The courts ruled that the city had acted improperly and returned Mr. Donnelly's Class A license to carry to him. Soon after the Springfield Police Department had been ordered by the Springfield Superior Court to return Mr. Donnelly's Class A firearm license, Mr. Donnelly then had applied to the Springfield Police Department to renew his state business license, that being of a Commonwealth Massachusetts hawker and peddler's permit, a business license that must be signed off by the chief of police in the city and town that one lives in. The Springfield Police Department clerk asked what he intended on selling. Mr. Donnelly stated that he intended to sell the book he wrote, Raw Emotion and Political Repression. Raw Emotion and Political Repression is a book that exposes corruption in Massachusetts. The Springfield Police Department retaliated against Mr. Donnelly and refused to sign off on the renewal of Mr. Donnelly's hawker and peddler's permit application. Mr. Donnelly could have lied to the Springfield Police Department about what he intended to sell, but Mr. Donnelly believes in honesty. Mr. Donnelly had never had any complaints during the year that Mr. Donnelly held an active hawker and peddler's permit, nor when he ran for mayor of Springfield or city council. Mr. Donnelly had campaigned by going door to door in the past, talking with residents. On May 10, 2021, the Springfield Police Department filed charges and requested a warrant against Mr. Donnelly in Springfield District Court as a result of Mr. Donnelly's lawful actions on April 24, 2021. Springfield case. The Springfield police officers who applied for the criminal complaint and warrant had lied in their application for the warrant/complaint and provided no paperwork to back up their false claims, paperwork that would have to exist if their claims had been true. The clerk just unlawfully, unethically rubber-stamped the Springfield Police Department's application. Mr. Donnelly was arrested by the Wilbraham Police Department at around 3 a.m. by an officer who Mr. Donnelly had previous negative history with. The officer had actually been involved in an unlawful activity in the past in regards to Mr. Donnelly. Mr. Donnelly complied with every order and went with the officers without a struggling or incident. Springfield Detective Timothy Schenck claims in his narrative for charges to be filed about Mr. Donnelly in the Springfield District Court case on April 12, 2021, that Springfield Police Deputy Chief S. Kent issued a LTC and firearm revocation service for Mr. Donnelly due to an open case, being the case out of Munson. Detective Timothy Schenck failed to include a copy of this revocation letter in his application for a warrant/criminal complaint. Deputy Chief Kent did not, in fact, revoke Mr. Donnelly's Class A license to carry, as is falsely stated. Detective Timothy Schenck never claims that the Springfield Police Department ever attempted to serve Mr. Donnelly with the alleged revocation notice during any time that Mr. Donnelly had an active Massachusetts Class A LTC, being prior to April 25th, 2021. The Springfield Police Department admit that they never attempted to notify Mr. Donnelly that his firearm license revoked prior to their phone call on May 7th, 2021. Once again, Deputy Kent did not revoke Mr. Donnelly's firearm license. If Mr. Donnelly's firearm license was revoked on April 12, 2021, the City of Springfield, Massachusetts failed to comply with the Massachusetts General Law, Chapter 140, Section 131F. Any revocation or suspension of a firearm license shall be in writing and shall state the reasons therefor. On April 25, 2021, Mr. Donnelly no longer had a valid Massachusetts Class A LTC, as it had expired on April 24, 2021. The Executive Director of the Criminal History Systems failed to abide by the Massachusetts General Law, Chapter 140, Section 131L. The Executive of the Criminal History Board Systems shall send electrically or by first-class mail to the holder of each such license to carry firearms a notice of the expiration of such license not less than 90 days prior to such expiration, shall enclose thereforth a form for the renewal of such license. If this letter had been sent to Mr. Donnelly would have renewed his Class A license to carry upon receiving the letter 90 days prior to the expiration and around 60 days prior to the false charges in Palmer District Court being filed. April 29, 2021, the City of Springfield's Police Department marks receipt of Mr. Donnelly's renewal application on said application, but then mailed Mr. Donnelly back his application with an uncashed check in violation of Massachusetts General Law, Chapter 140, Section 131, by failing to. The licensing authority shall provide to the applicant a receipt indicating that it received the application. The receipt shall be provided to the applicant within 7 days of the mail if the applicant was received by mail. The City of Springfield's Police Department failed to comply with this section of Massachusetts General Law, shows that due to the City of Springfield's Police Department that Mr. Donnelly's license to carry was not extended as they have claimed, as they failed to extend it by refusing to follow the Massachusetts General Laws. Envelope post office dated sent May 6, 2021 from the Springfield Police Department. The Springfield Police Department sent Mr. Donnelly back his whole renewal application, including his uncashed check for the renewal fee, with the inclusion of 2 documents, one being a Springfield Police LTC FID renewal application that differed from the official state application, with highlighted portions as stated that the City of Springfield was requiring the following extra documents: copy of a valid Massachusetts driver's license front and back, and a utility bill as proof of residency, copy of your current LTC, copy of your birth certificate, passport. Then they handwrote, "Please complete the attached form." The attached form asks for general information. This official letter document makes no mention of Mr. Donnelly having a revoked firearm license either. May 7th, 2021. At around 5 p.m. on Friday night, Mr. Donnelly was contacted by Springfield police officers, Detectives Timothy Schenck and Sergeant E. Podowski. In 2 separate phone calls, the officers informed Mr. Donnelly that his firearm license was revoked and that he had to turn in his firearms and Class A license to carry to the Springfield Police Department. Mr. Donnelly at first politely informed the officers that his firearms were in Vermont, a state that he was lawfully allowed to own firearms in, and that he no longer has an active Massachusetts firearm license to turn in, as it had expired on his birthday, being April 24th. Yet they still continued to order that Mr. Donnelly go to Vermont and retrieve his lawfully owned firearms and turn them into the Springfield Police Department. Mr. Donnelly continued to tell them that he was not going to turn in firearms that were in a location that he was lawfully allowed to own them in, and in a location state that they had no authority over. Mr. Donnelly also refused to meet with the officers because it was a Friday night, and Mr. Donnelly feared that if he met with the officers that they would have unlawfully arrested him for refusing to go to the state of Vermont in order to retrieve his lawfully owned firearms in order to turn in the firearms into the Springfield Police Department. Massachusetts Springfield Police Department. Mr. Donnelly feared being arrested on a Friday night and held until Monday in the Ludlow jail because Mr. Donnelly has had nightmares since he was unlawfully detained in said jail for 5 days. During these 5 days, Mr. Donnelly did not eat or drink anything and almost died as a result. In order to add more stress to Mr. Donnelly's deteriorating physical and mental state of being, they also left on a bright light 24 hours a day that the guards refused to dim or turn off, as well as refusing Mr. Donnelly anything to read, not even a Holy Bible, nor did they allow him church service or to speak to a priest. This was all done for posting on Facebook what had happened in open court. The offending Facebook post was a post exposing judicial corruption, and Mr. Donnelly won his case when it came to a jury trial. If the Springfield Police Department had in fact revoked Mr. Donnelly's Massachusetts firearm license on April 12, 2021, whether Mr. Donnelly had agreed with the Springfield Police Department, Mr. Donnelly would have immediately complied and brought his firearms and license down to the Springfield Police Department, as he had done in the past, without issue. The only issue with this time is that Mr. Donnelly did not have a Massachusetts Class A firearm license to turn in, nor did he have any firearms located within the boundaries of the Commonwealth of Massachusetts. On May 10, 2021, Officer Joseph Brodu filed charges as the complainant in docket number 2123CR002108, even though Detective Timothy Schenck is the person who wrote the narrative for this complaint, and Officer Joseph Broder had nothing to do with this incident. Detective Timothy Schenck willfully and maliciously made false statements in his narrative to the Springfield District Court in order to have an arrest warrant and criminal charges issued against a law-abiding citizen of the city of Springfield, Massachusetts. Detective Timothy Schenck referred to two of Mr. Donnelly's handguns as being AK-47s. These are not even close to being or even resembling AK-47s, but are antique Tokarev pistols, and were logged into the CGIS system as being that of firearm model TT33C. The firearm name AK-47 is a name that carries a negative image within certain groups of the population. Detective Timothy Schenck states on 4/12/2021, Springfield Police Deputy F. Kent issued a LTC and firearm revocation service for Mr. Donnelly due to an open case. Docket number 2143CR000501A. But does not state that the Springfield Police Department ever attempted to serve Mr. Donnelly with the notice prior to May 7th, 2021, thus making it appear as if Mr. Donnelly was hiding said firearms and license from the Springfield Police Department since April 12, 2021. Detective Schenck also failed to include a copy of this notice in his application for a warrant and criminal complaint. Detective Schenck states, next, pursuant to provisions of Chapter 140, Section 129D, of the Massachusetts General Law, anointed, Mr. Donnelly refused to deliver or surrender to the licensing authority, Springfield, Massachusetts, his LTC firearms, large capacity feeding device, rifles, shotguns, and ammunition owned by him or in his possession. Once again, Detective Schenck willfully fails to state that the firearm license in question is in fact expired and is no longer an active license, and that Mr. Donnelly had clearly explained that the firearm license was in fact no longer valid and not a license because it was expired. The Springfield Police Department never included in their application for this criminal complaint and warrant issue any proper or any legal documents that Mr. Donnelly had an active Class A LTC on May 7th, 2021. The Springfield Police Department never included any proof that Mr. Donnelly had any firearms located in the Commonwealth of Massachusetts. Mr. Donnelly was not precluded from owning firearms as a condition of his pretrial release on this other criminal case out of Palmer District Court. The Springfield police officers never disclosed who informed Deputy Chief Kent of the active charges out of Palmer District Court. Mr. Donnelly found out that the individual who informed Deputy Chief Kent of the active charges, Mr. Donnelly, is a Hamden County Assistant District Attorney, but it is unknown what Assistant District Attorney is the one who furnished this information to Deputy Chief Kent. In fact, the Assistant District Attorney who furnished Deputy Chief Kent with information actually provided Deputy Chief Kent with improper documents that could help clear Mr. Donnelly in the Palmer case. The Hamden County District Attorney's Office willfully hid this information from Mr. Donnelly in the Palmer District Court case. The Hamden County District Attorney's Office actions of contacting Deputy Chief Kent was done in order to circumvent the Honorable Michael E. McCulley, First Justice of the Palmer District Court's pretrial conditions order in the underlying Palmer District Court case. When Mr. Donnelly was arrested by the Wilbraham Police Department, he was given a cash bail of $540 at around 4 a.m. in the morning by the on-duty clerk magistrate, but was not provided with any access to an ATM in order to use his debit card. An ATM was located next door to the Wilbraham Police Department, if not within the police department itself. The Wilbraham Police Department had placed Mr. Donnelly in a dirty cell that had obviously not been cleaned or sanitized in some time. This caused Mr. Donnelly great worry, as he is a severe asthmatic and are in the middle of a global COVID pandemic. The Wilbraham Police Department then transferred Mr. Donnelly to the Ludlow Jail, also another hotbed for COVID. Even though by law, the Wilbraham Police Department was supposed to bring Mr. Donnelly to court for an arraignment first thing in the morning, a couple hours later. Mr. Donnelly was placed in a cell with bodily fluids all over it, and that had obviously not been cleaned or sanitized in a long time, as well as having stale air. This cell was not sanitized, and it was located in a COVID hotspot. The guards also took Mr. Donnelly's mask from him. The Ludlow Jail refused to release Mr. Donnelly for several hours after he was ordered freed by Justice Payne of the Springfield District Court. The Hampden County Assistant District Attorney had first requested that Mr. Donnelly be released on a $500 cash bail, but during the arraignment hearing, she changed it from $500 to $5,000 cash bail. This surprised Mr. Donnelly's public defender. Yes, they charged it from a $500 bail to a $5,000 bail within a half an hour. Yeah. Also, the Assistant District Attorney later told me that he changed it to $5,000 because his boss told him to. Strange. Justice Payne released Mr. Donnelly on the following conditions: either surrender firearms to the Springfield Police Department or provide affidavit from person firearms were turned over to by 5/17/2021 and personal reconnaissance of $500 personal survey. Mr. Donnelly was not released until around 2 hours later, after he had talked to a guard who had told him that just because a judge said he was released didn't mean that he could actually go home. After hearing this, Mr. Donnelly started banging his fists against the glass. After roughly half an hour of this, the guard came back to the window, and Mr. Donnelly informed the guard that he was going to do this until he shattered his hands, and that the prison would have to explain why Mr. Donnelly was still in their custody several hours after he was released. This was around 2 to 3 hours after Mr. Donnelly had been set free by Justice Payne. Mr. Donnelly was released soon after. Being that Mr. Donnelly is not required by Vermont law to have his firearms turned over to anyone and to exercise his rights under the Fifth Amendment of the Constitution, Mr. Donnelly is not going to say if, who, or where in the great state of Vermont his firearms are located, but will only say that they are located within Vermont, as such as a result of other people not wishing to become involved, and for good reason, as they fear backlash from the Commonwealth of Massachusetts if they were known. On Friday, May 14th, 2021, Mr. Donnelly contacted the Springfield Police Department in order to transfer Mr. Donnelly's firearms, as Justice Payne release's order had commanded, without a letter from a person in Vermont, even if his firearms were legally in Vermont. Mr. Donnelly had no other option than to bring them back into Massachusetts and turn them into the Springfield Police Department. Friday, May 14th, Mr. Donnelly called up the Springfield Police Department officers who had contacted him. The sergeant said that he had no idea who Mr. Donnelly was and had no idea about him turning in his firearms. Then Mr. Donnelly went to the police station to talk to someone in person. Mr. Donnelly talked to someone who told him that he would not be charged a storage charge for his firearms, and then Mr. Donnelly asked if, when he arrived with the firearms, if he could drive into the Sallyport actual building in order to turn them in. This officer told Mr. Donnelly that the officer in charge of his case didn't come in until 4 p.m. and would call Mr. Donnelly when he came in. The detective contacted Mr. Donnelly, told Mr. Donnelly that he would not be able to turn in said firearms because Mr. Donnelly did not have a Massachusetts firearm license, and it would be illegal for him to transport said firearms in Massachusetts. Mr. Donnelly explained that he had a court order from Justice Payne ordering him to turn over the firearms to the Springfield Police Department. The Springfield detective stated to Mr. Donnelly that the Springfield Police Department would send an officer to Vermont in order for Mr. Donnelly to surrender the firearms to the Springfield Police Department. Mr. Donnelly asked if they could do this either Saturday or Sunday because Justice Payne had ordered that they be turned over before court on Monday. The detective then said that he could not get an officer to do it during the weekend, but could on Monday morning. Mr. Donnelly explained that he could not do it on Monday morning because Mr. Donnelly had to be in court at 8:30 in the morning. The detective said, "Are you sure you have to be there, Mr. Donnelly?" He said yes. If he wasn't in court, they would have him arrested, and he would have to pay a $500 fine. The detective and Mr. Donnelly agreed that the Springfield police would go to Vermont on Wednesday at noon for Mr. Donnelly to surrender his firearms to the City of Springfield, Massachusetts Police Department. On May 12, 2021, the Springfield Police Department, in video, admitted that they never attempted to serve Mr. Donnelly with the revocation letter until the night of Friday, May 7th, even though it was issued on April 12th. They also refused to provide Mr. Donnelly a copy of the letter. And Mr. Donnelly respectfully refused to leave until they did, even though they were saying that them verbally informing Mr. Donnelly was all that they had to do. Mr. Donnelly quoted that the Massachusetts general law clearly states that it has to be in writing. One of the officers went into the police department to get Mr. Donnelly a copy of the letter. The letter that the Springfield Police Department provided Mr. Donnelly did not say that his license was revoked, but that it was only suspended until the case in Palmer District Court was resolved. This is in stark contrast to what the detectives had told Mr. Donnelly over the phone and what they had sworn to in their application for criminal charges and a warrant for Mr. Donnelly's arrest. You know what they say with a water bottle. Go big or go home. Or black is beautiful. On Wednesday, May 19th, 2021, Mr. Donnelly met with three Springfield police officers in the Vermont State Police parking lot in order for the Springfield Massachusetts Police Department to confiscate Mr. Donnelly's firearms as a result of the Massachusetts District Court judge's order allowing Mr. Donnelly's release from the Ludlow jail, and in disregard to Mr. Donnelly's rights under Vermont state law, as Mr. Donnelly is lawfully allowed to own and possess firearms in the state of Vermont. Mr. Donnelly, being a law-abiding citizen, turned over all of his firearms, including firearms that were not on the list provided by the Springfield Police Department. On Monday, May 24th, 2021, Mr. Donnelly had gone to the Springfield District Court in order to prove that he had turned over his firearms to the Springfield Police Department. After the hearing, the clerk came up to Mr. Donnelly and told him that he had to sign his pretrial conditions, something that he had done prior, but they claimed that he had not. May 25th, 2020, hours after leaving the Springfield District Court, Mr. Donnelly read the pretrial paperwork and noticed that no mention of Vermont was included, only that Mr. Donnelly had to turn in his lawfully owned property, being firearms, over to the Springfield Police Department, and that as part of his pretrial conditions, that Mr. Donnelly was not allowed to own firearms in this case, meaning in any state. Justice Payne of the Springfield District Court did in fact violate Mr. Donnelly's civil rights, as well as his rights under the Vermont State Constitution, by ordering that Mr. Donnelly surrender firearms to the Springfield Police Department, firearms that Mr. Donnelly was legally possessing in the state of Vermont, all as a result of Mr. Donnelly's not having a firearms license in the Commonwealth of Massachusetts, being a state that, at the time, Mr. Donnelly did not have a firearm license located in. On May 24th, 2021, Mr. Donnelly served Hampden County Assistant District Attorney Hobbs and the Springfield District Court with a motion to dismiss in open court. Springfield District Court Justice Santinello scheduled the motion to be heard on July 8th, 2021. What needs to be mentioned too is when I actually went to court to have that motion heard, that motion had been removed from the file by someone. So someone who works for the Springfield District Court went into the legal file and actually removed that motion and discarded it. In early to mid-May, Mr. Donnelly called the Palmer District Court Clerk's office and inquired as to when they were going to mark up his motion to dismiss for. The clerk's personnel gave Mr. Donnelly a hard time and told him that they did not mark up motions and that he had to when Mr. Donnelly asked what he needed to do this, they were very rude and refused to tell him. It was very noticeable that they had read his motion to dismiss as it claimed misconduct on their end. Mr. Donnelly had called other district courthouses that the clerk's office normally schedule a hearing date for motions to dismiss. Mr. Donnelly contacted Hamden County Assistant District Attorney Catherine Joyce, being the Assistant District Attorney assigned to the Munson case, Palmer District Court, and asked her if she would like to pick a date to have the case heard. Assistant District Attorney Joyce was very rude and said that she did not want to hear it until the next court date. Then she hung up on Mr. Donnelly. On June 9th, 2021, in his scheduled time of 8:30 a.m., Mr. Donnelly arrived and checked in with the Palmer District Court in order to have his motion to dismiss heard. When Mr. Donnelly noticed that the courtroom opened, Mr. Donnelly went into the courtroom and patiently awaited his case to be called. At around 10:30 a.m., Mr. Donnelly heard the presiding justice asked the court clerk if that was all the cases. The clerk court said that was all the cases. Mr. Donnelly respectfully approached the court officer that was present and asked the court officer about his case. The court officer said to Mr. Donnelly that the assistant district attorney was not ready for his case. The fact that everyone in the Palmer District Courthouse, from the court officers, clerk magistrate, and even possibly the presiding judge, were aware Assistant District Attorney Joyce was not ready, nor prepared to proceed, and that Mr. Donnelly, a pro se litigant, who is supposed to be treated as that of any other attorney and not being aware of this situation, shows that Assistant District Attorney Joyce was involved in ex parte communication with the court, thus causing Mr. Donnelly great stress and anxiety. After the presiding justice left the bench, the court officer emptied and locked the courtroom, and Mr. Donnelly went into the main courtroom lobby. While in the lobby, and with the understanding that the assistant district attorney was in ex parte communication with the members of the court, Mr. Donnelly was starting to have an anxiety attack. So he laid down on the bench that he was sitting on in order to relax, as Mr. Donnelly has a medically documented generalized anxiety disorder as a result of the governmental corruption that he has faced over the past 12 or 13 years. And as a result, Mr. Donnelly has a prescription for medication in order to help him with this disorder. As a result of Mr. Donnelly being a pro se litigant, Mr. Donnelly was not in a position to take said medication, as it would have interfered with Mr. Donnelly's ability to argue his motion. And as a result, Mr. Donnelly would have opted to try and relax in order to calm down, as anxiety attack affected Mr. Donnelly's breathing. Mr. Donnelly is also a lifelong sufferer of extremely severe asthma. And when I say extremely severe, I mean I've been hospitalized for asthma. My lungs really don't like me. When Mr. Donnelly was lying on the bench with his eyes closed, trying to relax, Mr. Donnelly was also wearing a mask, just out of respect for the other two people who were in the lobby. Even though Mr. Donnelly is fully vaccinated, and the governor had rescinded the mask order and was in compliance with the Center for Disease Control, and that due to Mr. Donnelly's medical conditions, he was not required to comply with the mask mandate. Court Officer Hart approached Mr. Donnelly in a very rude and disrespectful manner, and in a very demanding and rude manner told Mr. Donnelly to get his feet off the bench because this was not his home. Then Officer Hart walked away. Court Officer Dennis Hart claims he was observed lying on a court lobby bench with no mask on. Officer Dennis Hart spoke with him. Mr. Donnelly became agitated. This is in fact a lie, as Mr. Donnelly had a mask on when Officer Hart spoke to Mr. Donnelly, and will be fully visible in the courthouse recordings. In fact, Court Officer Hart had no authority or reason to even interact or approach Mr. Donnelly, as Mr. Donnelly was committing no criminal action or violation in the courthouse lobby. Oh yeah, I need another drink. Parched. When Mr. Donnelly sat up, he respectfully approached Officer Hart at this point and reminded him that Mr. Donnelly was fully vaccinated, Mr. Donnelly had been asked upon entering the courtroom if he was fully vaccinated and was an asthmatic as well, and was going to be taking off his mask because Mr. Donnelly was having a hard time breathing. Mr. Donnelly did not inform Officer Hart of his anxiety disorder, as he felt that Officer Hart was going to relay this information to the Assistant District Attorney, and that this information could be used against Mr. Donnelly, especially seeing I'm representing myself. Mr. Donnelly then went to the lobby in order to relax as best as he could, sitting up and in full compliance as he had been ordered by Officer Hart. When in the lobby, Mr. Donnelly was approached by Assistant Chief of the Court Officers, Miss Cardozo, who then acted in a very rude and dismissing manner to Mr. Donnelly. Mr. Donnelly explained his medical condition to Officer Cardozo, and Officer Cardozo did not care. And all that she would say was, "Do you have a doctor's note?" And Mr. Donnelly reached into his pocket and showed her his emergency asthma medication in order to prove to her that he has a chronic respiratory condition, and explained how it was causing him to have trouble breathing. And all that she would reply to him was that it was not a doctor's note. But if Mr. Donnelly had a doctor's note, he would not have to wear the mask. Mr. Donnelly asked her many times if she was asking him to wear a mask, or if she was ordering him to wear a mask. And if she was asking him to wear a mask, then Mr. Donnelly was not going to wear it. But if she was ordering Mr. Donnelly to wear the mask, then he would comply with her order. She just would say that she was asking him to. Then she said if he was not going to put on the mask, that she was going to be removing Mr. Donnelly from the building. Upon being threatened with removal from the building, if he did not put on the mask, Mr. Donnelly then put on the mask. At no time did Mr. Donnelly raise his voice, become agitated, or act out during the whole encounter with Officer Cardozo. Mr. Donnelly stayed calm, cool, and collected, wherein Officer Cardozo had an attitude and was acting with disregard to Mr. Donnelly's stated medical conditions. Also, what needs to be noted, too, is one of her court officers that came out to assist her, the one that actually physically assaulted me, didn't have his mask on. His mask was covering his mouth with his nose wide open. Okay. After Mr. Donnelly put on his mask, Mr. Donnelly respectfully informed Officer Cardozo that he was going to be taking legal action against her, and Officer Cardozo, instead of walking away from Mr. Donnelly, who was now wearing a mask, as she had ordered him to do, and noticing that Mr. Donnelly was not filming, Officer Cardozo then became verbally combative with Mr. Donnelly, ordering him to leave. Mr. Donnelly respectfully informed her that he could not leave because he had official court business, as she was well aware of, that Mr. Donnelly was waiting for a motion to dismiss to be heard. Mr. Donnelly also feared that if he did leave the courthouse, that when his case was called, that they would say that he was not present, and thus why Mr. Donnelly had waited in the courtroom all morning for his case to be heard. Officer Cardozo then told Mr. Donnelly that if he did not leave, that he was going to be arrested. When Mr. Donnelly would inquire what for, Officer Cardozo was not able to articulate the reason why. Mr. Donnelly stayed calm, cool, and collected, as he knew that he was violating no laws. Even though Mr. Donnelly was committing no criminal action other than informing Supervisory Officer Cardozo that he was intending to file a complaint against her, Supervisory Officer Cardozo ordered her court officers to place Mr. Donnelly under arrest. To Mr. Donnelly's disbelief, not only was he placed under arrest, but even though he was not physically resisting, the court officers physically abused Mr. Donnelly, including placing handcuffs extremely tight on his wrists and performing wrist locks on him and smashing his head against the wall in the courtroom lobby. It is widely known that if a wrist lock is applied suddenly and or forcefully, a wrist lock can cause ligament tears or possibly even dislocation or bone fractures. This action did in fact result in Mr. Donnelly suffering from bone bruising in his wrists, as is provided by the included Emergency Department Discharge Summary from Bay State Wing Hospital on June 10th. That is included. Mr. Donnelly was then brought to the holding cell in the basement of the courthouse. During the transport, the court officers were still attempting to cause lasting disability and extreme pain to Mr. Donnelly's wrists. Upon entering the cell, the court officer smashed Mr. Donnelly's head against the corner of the cell's metal bar door. When inside the cell, the court officers lifted Mr. Donnelly up and smashed his knees into a solid metal bed, resulting in Mr. Donnelly's knees being injured, resulting in bruised bones in his knees, as stated in Mr. Donnelly's medical report. The officers then forced his head down and against the brick wall, twisting his back and shoulders against the wall, as well as digging what appeared to be their knees into Mr. Donnelly's butt in the location of his sciatic nerve, causing more lasting physical discomfort and pain. Mr. Donnelly was left in the cell not only in pain, but with his hands cuffed behind his back and with leg irons on, meaning that Mr. Donnelly was placed in a position where he could not even lay flat on his back. Mr. Donnelly was placed under arrest by the Massachusetts District Court Department court officers at around 10:40 a.m. Unknown to Palmer District Court magistrate, likely the same magistrate who Mr. Donnelly had labeled as corrupt in his motion to dismiss, now allowed the new charges that the court officers filed against Mr. Donnelly to proceed without a show cause hearing and without viewing the available audio and video of the incident. Nor would the clerk magistrate even provided with a full statement from even one of the court officers, being the only one to write one. Thus, the clerk magistrate rubber stamped the complaint. Yeah, the officer that assaulted me is the only one that wrote a complaint, not Hart and not Cardozo. And they didn't even provide the video evidence, which is what happened. All right, unknown to Palmer District Court magistrate scheduled Mr. Donnelly for an arraignment at 2 p.m. Mr. Donnelly was not brought up for his arraignment on these new charges until 3:30 p.m. It is unknown why out of the 4 court officers who were present, Officer McBride, Officer Hart, an unknown court officer, and Assistant Chief Cardozo, while the only court officer to make an official report was Officer McBride. And if other officers made official reports, why they were not presented to the court or to Mr. Donnelly, who was a pro se litigant, self-represented defendant. Officer McBride's statements state that it is a partial statement, as of 20 days later, Mr. Donnelly, being a pro se litigant, has not been furnished with a full statement by any member of the Massachusetts Trial Court Department officers, nor has he been provided with any video or audio evidence that was taken at the courthouse. The courthouse is covered by, at the very least, video recordings. Mr. Donnelly was held in the cell in the Palmer District Court for around 5 hours. During these 5 hours, Mr. Donnelly had asked numerous times to make a phone call in order to contact his family's private attorney. The court officers, and more importantly, Assistant Chief of the Court Officers, Ms. Cardozo, refused Mr. Donnelly's request. In doing so, they willfully violated Massachusetts General Law, Chapter 276, Section 33A, by not allowing Mr. Donnelly the use of a phone within an hour of his arrest detainment, thus isolating Mr. Donnelly. Hampden County Assistant District Attorney and former Massachusetts Administrative Law Judge David Chivers, Chivers, requested that the Palmer District Court revoke Mr. Donnelly's bail in the Munson case, the case that Mr. Donnelly had showed up to court that day in order to argue his motion to dismiss in. Hampden County Assistant District Attorney and former Massachusetts Administration Judge David Chivers gives as one reason for his request to revoke Mr. Donnelly's bail, as a defendant is alleged to have violated the conditions of his release on docket 2143 CR 501 Munson case. Hampden County Assistant District Attorney and former Massachusetts Administration Law Judge David Shivers gives us another reason requesting to revoke Mr. Donnelly's bail. Upon information and belief, this defendant was on pretrial probation as a result of these allegations. Assistant District Attorney Shivers is claiming that Mr. Donnelly and the Hampden County District Attorney's Office, with the approval of some unknown district court judge, are in agreement that prior to the pretrial hearing that if Mr. Donnelly stays out of trouble, that the Munson case is going to be dismissed. If that was the situation, then the Munson case should have been dismissed on June 9th, being the day in question, which the ADA, says District Attorney Joyce, seems to have had no intention of. Hampden County Assistant District Attorney, former Massachusetts Administration Law Judge David Shivers gives us another reason requesting to revoke Mr. Donnelly's bail, as upon further information and belief, the Commonwealth alleges this defendant violated conditions of release by new arrest for disrupting court proceedings. It must be stated that when Mr. Donnelly was arrested, court was not in session, as the presiding justice had already left the bench for the morning session. It appears that Hampden County Assistant District Attorney and former Massachusetts Administrative Law Judge David Shivers was attempting to have Mr. Donnelly's bail revoked because he knew that Mr. Donnelly was facing false charges and knew that if Mr. Donnelly was allowed to proceed with his motion to dismiss, that Mr. Donnelly was going to not only win his motion to dismiss, but was going to expose corruption. The presiding justice did not revoke Mr. Donnelly's bail during the arraignment, but scheduled Mr. Donnelly's next hearing for the exact day that Mr. Donnelly had a motion to dismiss scheduled for a Zoom hearing in the Springfield case. Mr. Donnelly, being a pro se litigant, informed the justice that that day would not do, and the judge told him that he was going to have to file a motion for a continuance then. Mr. Donnelly has never heard of this, as in the past, court dates are agreed upon between the prosecution, defense, and the court. At Mr. Donnelly's arraignment, the Palmer District Court did not provide Mr. Donnelly with the whole case file, as is required by the Massachusetts general law. And yet, even like almost 6 months later, I still don't have the videos. Okay, now we're getting into the issues. Issue number 1. Mr. Donnelly did not violate Massachusetts General Law, Chapter 272, Section 53, being that of the Criminal Act of Disorderly Conduct. Argument number 1. The crime of being a disorderly person is defined as engaging in fighting or threatening violence or turbulence behavior or creating a hazardous or offensive condition that serves no legitimate purpose. The actions of Mr. Donnelly in the lobby of the Palmer District Court on the day in question does not even come close to meeting this legal definition. Mr. Donnelly was exercising his First Amendment right to freedom of speech and was only talking in a normal voice level to the court officers in a public lobby. On the day in question, Mr. Donnelly was in a mostly empty courthouse lobby with 3 other citizens, 1 woman who was on her phone, and 2 men. Each person had a good amount of distance between themselves, being well over 6 feet. Mr. Donnelly is a severe asthmatic and was in the process of having an anxiety attack as a result of learning that the assistant district attorney was involved in ex parte communications with the court, and that Mr. Donnelly's motion to dismiss, claiming corruption, was not called to be heard, as it had been scheduled for. In fact, the presiding justice has inquired to the clerk if that was all the case, and the clerk affirmed that it was. Then the presiding justice left the bench, and Mr. Donnelly respectfully approached the court officer stationed inside the courtroom, inquiring about his motion to dismiss. And the court officer informed Mr. Donnelly that the assistant district attorney was not ready to argue Mr. Donnelly's motion to dismiss. Mr. Donnelly's motion to dismiss is almost 40 pages in length, with another couple hundred pages of exhibits, meaning that if Assistant District Attorney Joyce had not been ready when she arrived to defend against Mr. Donnelly's motion to dismiss, then there was no way that she was going to be prepared any time that day to defend against Mr. Donnelly's motion to dismiss that day. As a direct result of the court officers arresting Mr. Donnelly, this provided Assistant District Attorney Joyce another month to prepare. Palmer District Court's actions are a violation of Mr. Donnelly's request for a speedy trial, being a request that had been granted at Mr. Donnelly's arraignment. When the presiding justice set the date for Mr. Donnelly's pretrial conference motion to dismiss date, anxiety attacks can feel like and can also set off asthma attacks if one is not able to control them. In order to self-medicate, control his feelings of anxiety, a condition that Mr. Donnelly has been diagnosed with the medical diagnosis of generalized anxiety disorder, GAD, Mr. Donnelly laid down on a courthouse bench in order to relax and regain his nerves. Court Officer Hart falsely claims that Mr. Donnelly did not have a mask on when Officer Hart claims that he approached Mr. Donnelly. Video footage will prove that Mr. Donnelly did in fact have a mask on and eyes closed when Officer Hart approached Mr. Donnelly. Instead of informing Mr. Donnelly to put a mask on, Officer Hart told Mr. Donnelly to take his feet off a bench and that the courthouse was not his house. Officer Hart said this in a very rude manner. There are no laws that Mr. Donnelly is aware of that precluded Mr. Donnelly from sitting in the manner as he was sitting. Audio footage will show that Mr. Donnelly did not, in fact, say to Assistant Chief Cardoso that the officer. Audio footage will show that Mr. Donnelly did, in fact, say to Assistant Chief Cardoso that the court officer had given him a hard time and told him that the courthouse was not Mr. Donnelly's home. Mr. Donnelly, in a calm voice, did in fact inform the court officers that he was fully vaccinated and that the governor and the CDC had lifted the mask mandate. He is an asthmatic, has a chronic respiratory illness, and was having a hard time breathing. Mr. Donnelly even showed Assistant Chief Cardoso his ProAir HFA, a butyral inhaler. Being a prescription medication, Assistant Chief Cardoso claims to be an asthmatic as well, and thus was fully aware not only by the fact that Mr. Donnelly had informed her that it was an emergency prescription breathing medication, but would have known as a result of her own medical condition. It is widely known that not everyone suffers from the same level of asthma. Mr. Donnelly stated that due to his breathing condition that he was not going to be wearing a mask as he waited in the lobby of the courthouse, unless he was ordered to do such. Assistant Deputy Cardozo continued to ask Mr. Donnelly to put on the mask, and Mr. Donnelly would respectfully reply that if she was simply asking, that he would not. But if she was ordering him to, that he would comply. At one point, Mr. Donnelly told her that if she wanted him to put on the mask, to just order him to, and that he would comply. During this conversation is when the other court officers arrived. There is audio footage of this incident directly contradicting what the court officers claim happened, as Mr. Donnelly was not being loud. Mr. Donnelly was only speaking and not disrupting anyone in the lobby. Video footage will show that a woman who was sitting in the lobby was not even paying attention, but was only looking at her phone, the exact same thing that she had been doing all morning. Assistant Deputy Chief Cardozo also had stated that if Mr. Donnelly had a doctor's note, that he would have been able to go without a mask, but nowhere does it say that someone needs a doctor's note to go without a mask. In fact, the governor's office gives a very detailed listing of locations that masks are still required in, and none of the listed locations are courthouses. Some of the exemptions to these locations wherein a person can go without a mask are as follows. Persons for whom face mask covering creates a health risk or is not safe because of any of the following conditions or circumstances. Number one is that the face mask or covering affects the person's ability to breathe safely. The person has a mental health or other medical diagnosis that advises against wearing a face mask or covering. This could include being diagnosed with generalized anxiety disorder. It is unknown where the Massachusetts District Court Department, an entity charged with the handling of legal matters within the Commonwealth of Massachusetts, is getting their guidance in regards to how they're handling the COVID virus. The Massachusetts District Court Department is an entity that deals with the law and not public health, and as such, the court should be complying with the Center for Disease Control and Prevention, better known as the CDC, and the Massachusetts Department of Public Health recommendations. Mr. Donnelly complied with the Assistant Deputy Chief when she gave Mr. Donnelly an ultimatum to put on the mask or that he had to leave the courthouse. At this point in time, Mr. Donnelly felt that he was no longer being asked to put on the mask, but was in fact being ordered to do so. This was as a result of if Mr. Donnelly was to leave the courthouse, Mr. Donnelly believed that he would miss his hearing, resulting in a warrant for his arrest to be issued. So Mr. Donnelly said okay and put on the mask. Once Mr. Donnelly complied with the court officers by putting on his mask, the encounter should have ended right then and there. At this point in time, the court officers, after having their order complied with, instead of being content, decided to then threaten Mr. Donnelly with arrest and then arrested and physically abused Mr. Donnelly. Even though Mr. Donnelly had committed no criminal activity, the crime of disorderly conduct is often used when a member of law enforcement is upset with an individual and can think of no other criminal action to charge the person with. In this case, it is very clear that Assistant Deputy Chief Cardozo was upset with Mr. Donnelly for not only not putting on a mask when she asked him to, but for informing her that he was going to be taking legal action against her for ordering him to do so. It is claimed by Court Officer McBride that Mr. Donnelly was arrested and charged with disorderly conduct because Officer McBride alleges Mr. Donnelly became agitated and was uncooperative. In Commonwealth v. Earl Shawley, 48 Mass, APPCT C 495, 1999, the court ruled, in quotes, at the trial of a complainant alleging the defendant was a disorderly person in violation of GLC 272S53, evidence of the defendant's loud use of obscenities in a public place without more was insignificant to warrant submission of the case to the jury. The defendant's motion for a required finding of not guilty should have been allowed. In quotes, 499 through page 500, quotes. Mr. Donnelly is respectfully requesting that this case be dismissed because given the above reasoning, Mr. Donnelly has violated no criminal statute or law. Okay, issue number 2. Mr. Donnelly did not violate Massachusetts General Law, Chapter 268, Section 32B, being resisting arrest. Argument number 2. The crime of resisting arrest is defined as an individual commits the crime of resisting arrest if he knowingly, meaning he must know the person is a police officer, prevents or attempts to prevent a police officer who is acting under the color of his official authority from effectuating an arrest by, number 1, using or threatening physical force, or 2, using any other means that create a substantial risk of causing bodily injury to the police officer. Mr. Donnelly disagrees with Court Officer McBride's allegations, but still, even given what Court Officer McBride is claiming, Mr. Donnelly was doing, and I stress, this is claimed to have only occurred after Mr. Donnelly had allowed the officers to handcuff him. Officer McBride claims that Mr. Donnelly was attempting to pinch and step on officers' feet. Even though Mr. Donnelly strongly disagrees with this allegation, the truth of the matter is that this does not reach the level of resisting arrest as defined within the law, as Mr. Donnelly was not threatening physical force, nor was he using any other means that created a substantial risk of causing bodily injury. Stepping on someone's foot is something that Mr. Donnelly does not recall happening, but could have happened when he was trying his best not to fall face first on the floor. And the allegation of pinching, something that Mr. Donnelly did not in fact do, are the only alleged physical actions claimed by Officer McBride. But the truth is, Mr. Donnelly is the one with the medical records providing physical injuries. This is not the first time that Mr. Donnelly has been unlawfully placed under arrest. This is said to be unlawfully because Mr. Donnelly has never been found guilty of any criminal offense. Also, every arrest can be traced back to corrupt actions taken by the state and local agencies, with all of them related to the Hamden County District Attorney's Office. And in each and every incident, Mr. Donnelly has never physically resisted, nor had it ever been alleged that he had physically resisted in the past. On May 11th, 2021, just a matter of weeks prior to this incident, at around 3 a.m., Mr. Donnelly was in a gas station in Wilbraham, Massachusetts, making a tea, when several Wilbraham police officers, including one officer who had been involved in illegal activities against Mr. Donnelly in the past, arrived. One of the officers informed Mr. Donnelly that he had a warrant issued for his arrest. The officers and Mr. Donnelly walked out of the gas station and to one of the cars. Mr. Donnelly complied with the officers. They placed handcuffs on him and he complied without issue. Body camera and intake video exist of this incident. In fact, Mr. Donnelly is even joking with the officers present. Because honestly, after all, they did have a valid warrant for my arrest and they were doing their job, even though, it was, yeah. But still, I'm not going to fight with cops, like what am I going to do? Fight with them and get shot? Come on. On May 19th, 2021, Mr. Donnelly complied with an illegal order out of Springfield District Court when Justice Payne ordered Mr. Donnelly to turn over his lawfully owned firearms that were being kept in the state of Vermont, where Mr. Donnelly was legally allowed to own said firearms after his Massachusetts firearm license had expired. Mr. Donnelly had even tried to surrender the firearms on the previous Friday, but the Springfield police told him to wait 6 days because they didn't want Mr. Donnelly to bring them back to Massachusetts without a valid Massachusetts firearm license, and that they were not able to send anyone to Vermont until Wednesday, May 19th. The officers who went to Vermont to collect the firearms thanked Mr. Donnelly for making the confiscation easy. Once again, Mr. Donnelly complied, and even if it was an illegal order, as a bona fide firearm collector of late 1800s to mid 1900s firearms, the firearms that Mr. Donnelly turned over are worth a lot of money. So yes, I'm going up into another state and turning over a lot of money worth of firearms, into antique firearms, to a police department that is being done off of an illegal court order. Strange. A court order that's allowed because I brought the firearms out of state. Alright, so close to 10 years ago, Mr. Donnelly's roommate let officers into Mr. Donnelly's home, and Mr. Donnelly was arrested for posting on Facebook what had happened in court. State agencies had retaliated against Mr. Donnelly for filing lawsuits against them and writing a book exposing their corrupt activities. Mr. Donnelly won this case in a jury trial, but he was arrested in the early morning after being awoken for over 24 hours straight, writing reply legal motions. Mr. Donnelly once again complied without issue. The officers present were representing agencies that he had filed suit against. These officers also searched Mr. Donnelly's home, including his filing cabinets, dressers, books on his bookcase, and computer, even though the officers only had a arrest warrant and not a search warrant. Then around 6 or so months later, when Mr. Donnelly had a motion to dismiss set to be heard, Mr. Donnelly was awoken around the same time, early morning hours, because the Hamilton County District Attorney's Office alleged a violation of Mr. Donnelly's pretrial conditions in that case, because someone had contacted a news internet story. Someone had corrected a news internet story on Mr. Donnelly's behalf in relation to Mr. Donnelly's running for office. And once again, Mr. Donnelly, even when half awake, complied. Only this time, Mr. Donnelly met the officers at the door. The officers told Mr. Donnelly that if he wanted to get changed, they would let him. But Mr. Donnelly just left the way he was, knowing that the officers wanted to search his files again. Mr. Donnelly was released with a finding that he had not violated his conditions after Justice Philip Content had held Mr. Donnelly in the Ludlow House of Corrections from his arrest on Friday morning and brought back to court on Tuesday morning, while he decided if Mr. Donnelly had violated his pretrial conditions or not. Mr. Donnelly had made an official complaint against this justice a couple months prior. After Justice Content released Mr. Donnelly, Justice Content stated to Mr. Donnelly that there would be reactions for actions. One must also figure in Mr. Donnelly's law enforcement training. Mr. Donnelly had partaken in the same or very similar use of force training as the trial court officers have. Also, Mr. Donnelly had taken many years of mixed martial arts training and had competed on the amateur level in the sport of boxing. And I played football for 4 years as a defensive and offensive tackle. So yes, I put people down. One must also figure Mr. Donnelly's if a person with Mr. Donnelly's knowledge and training would have intended to resist, said person would have started resisting prior to being grabbed and handcuffed. Mr. Donnelly did not in fact stiffen up and tried to keep his balance because he was not being arrested, but was being physically assaulted. And Mr. Donnelly was trying not to be seriously or permanently injured. There was no need to smash Mr. Donnelly's head against 3 separate walls, to lift and smash his knees against a metal bed, to dig a knee into his sciatic nerve, or to hurt his wrists so bad that the wrist's bones were bruised. This was clearly done in retaliation for Mr. Donnelly's refusal to wear a mask in order to cover for their behavior. They claimed that Mr. Donnelly was resisting. Making these claims are typical in law enforcement when the perpetrators are trying to cover up for their use of excessive force. Yes, I've seen it happen. I've seen it happen when I worked in DYS and everything else. They cover up as much as they can. Mr. Donnelly is not only an artist, but a motorcyclist. And this is motorcycle season, and as such, the enjoyment of both of these pastimes would be greatly affected with 1 or 2 broken wrists. Something that Mr. Donnelly would be well aware of being a potential if he had attempted to resist. If Mr. Donnelly had been actively resisting, he would have suffered breaks to the wrists and his bones, and not just bruises. It must also be asked, is a court officer a police officer, or are they security officers? After all, they are unarmed, and from MassGov and the recruit manual, the head of the Massachusetts trial court is listed as Director of Security, CEO, and with a mailing address listed as Massachusetts Trial Court Security Department, wherein with the Massachusetts Department of Youth Services is in all regards a youth jail system with employees who are in all purposes youth prison guards, yet the inmates are listed as residents and the guards are listed as direct care workers. And besides the fact that Mr. Donnelly has a long history of physically complying with arrests, including false arrests, actually all of them are false arrests, if these court officers were not legally classified as being police officers, as is stated in the Massachusetts general law, as they must, then this count fails on the fact that they are not, for all lawful purposes, listed as being security guards and not as police officers. A valid defense to a charge of resisting arrest is stated in Commonwealth versus Frederick R. Moreira, Moreira, dot 388 Mass 596 January 5th, 1983 to March 29th, 1983, Middlesex County, in quotes. However, where the arresting officer uses excessive force in his attempt to subdue the arrestee has the right to use such force as is reasonable and necessary to repel such excessive force, end quote. Having a court officer grabbing and putting someone who is not resisting or breaking any law into a wrist lock then smashing the person's head into 3 separate walls of the courthouse, causing a concussion as well, as at the same time applying enough pressure to the point a person's wrists that the bones in the person's wrists are bruised, while applying pressure with a knee to a person's sciatic nerve, and picking up and smashing a person's knees onto a solid metal bed. If this is not excessive force, then not much is. This is especially true when the arrestee has a history of not physically resisting, and when the claimed cause for arrest is a provable lie, as would be shown in the videos. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no criminal law or statute. Okay, now the last issue. Issue number 3. Mr. Donnelly did not violate Massachusetts General Law, Chapter 268, Section 13C, being disruption of a court proceeding. The crime of disruption of a court proceeding is defined by the Massachusetts General Law as whoever causes or actively participates in the willful disruption of a proceeding of any court of the Commonwealth. To be responsible for a violation of this criminal statute would mean that Mr. Donnelly would have not only have to have disrupted a court proceeding, but would have also had to have the willful intent to do such. In no way can this be proven by the state because not only was Mr. Donnelly under the understanding that the judge was not hearing any matters at the present time, as Mr. Donnelly had been aware that the presiding justice had already left the bench for morning call, as Mr. Donnelly had been physically present when the judge left the bench not long prior to the situation. Also, if the justice would have still been hearing matters, Mr. Donnelly would have still been waiting patiently in the courtroom for his case to be heard. If on the long shot a hearing was taking place during this encounter, this would have meant that the court was willfully keeping the matter being heard private, as the courtroom was closed to the public when this incident occurred. This is not only highly unlikely, but if this is the case, then there was no way for Mr. Donnelly to be aware of a hearing taking place, thus once again taking away the willful intent. In Commonwealth v. Earl Shawley, 48 Mass. APP CT 495, 1999, in quotes, at the trial of a complaint for violation of GLC 268, Section 113C, the evidence fails to establish that the defendant actually disrupted a trial or other court proceeding by his loud outburst in the courthouse corridor and stairwell, and the defendant's motion for a required finding of not guilty should have been allowed. End quotes. In the previously stated case, Mr. Earl Shawley was creating a loud outburst, where in the present case, Mr. Donnelly was talking in a normal tone to the court officers, and a justice was not in the courtroom. And in fact, Mr. Donnelly was waiting for his motion to dismiss to be heard, and to disrupt the court proceeding is the fastest way to get a judge upset and to make sure that his motion was ruled against. Mr. Donnelly is respectfully requesting that this case be dismissed because, given the above reasoning, Mr. Donnelly has violated no criminal law or statute. Conclusion. As a matter of law, Plaintiff Commonwealth Massachusetts fails to meet even the minimum requirement, and as such, Mr. Donnelly respectfully requests that these charges be dismissed without delay. Dated 29th June 2021. I know you just listened to all that for an hour and 18 minutes or so, and you know what the thing is? The judge didn't even let me read that motion. Didn't even let me argue the 3 issues. Just denied it. Yeah. So now this is going to trial. Have a good one. And once again, buy one of my books. Donate at my PayPal, which is jpdonnelly8@aol.com. Buy a painting. Do whatever you can do. Just, if you can, help support the cause, because all the money I'm making is going to this fight to expose corruption. Have a great day.